Article basically 217 of 2024.
Yes.
My lord, my basic case before the single judge was that, my lord. That, my lord, I have taken part in a tender floated by the General Manager Construction and Appraisal for supplying of some cables around 42,000 meter cables were to be supplied to the end. I furnished all the documents which was required. As per the bid conditions, I am supposed to give the turnover of last 3 years. I have submitted the turnover. Now, on 10/6, 18/4 was it?
So that's okay. What the department's view is that you did not supply this information at the time of filing the tender.
I was to supply only that much of the information they have required, my lord. My lord, your lordship will kindly consider that in the representation, there is a provision in the bid itself, that there will be 2 days time for clarification. No clarification was sought.
Clarification on the basis of information which you have supplied.
True, my lord. Information supplied, my lord, they were with all the information that the partnership firm is taking part in the tender process. They say that you have supplied the turnover of the proprietorship firm. That is the basic yeah.
So you're a partnership firm. When you want to supply documents pertaining to works executed while the firm was a proprietorship firm, it naturally entails that some clarification ought to have been furnished while along with the papers.
That was not required. Only turnover was asked for, so that was submitted. That is my submission. And I have submitted the representation. Representation was also without considering my document. They say that you have submitted additional document, so it will not be considered.
Now, what is the stage?
Well, stage, my lord, so far I have my client's instruction is concerned, my lord. Till now, the matter is pending before the my lord. After the reverse auction process is over on 18th, my lord, the matter was moved on, my lord, 18th. My initial lead petition, and 19th the order was passed. The financial reverse auction process has been completed on 18th, and the matter, the file is lying before the general manager, my lord, in April. No order has been passed, no contract has been awarded. That is my instruction, and I have made a statement to that effect also.
No. This is a 2-bid system.
2-bid system, technical, my lord, and then financial bid.
So you were rejected at the technical.
Technical itself, my lord.
So what financial bid? Has it
financial bid was open, my lord.
Process has already been completed last year. Only the letter of acceptance.
What is to be done now?
Yes, sir.
No, letter of acceptance has not been given, my lord. That is
the process is complete.
Price bid has been opened now.
Price bid has been opened, true, my lord. But I didn't get a time to come to before this honorable court, before the price bid was opened, my lord. 14th, my representation was they have communicated in the night, my lord, at 7 something, my lord. 15, 16, 17, my lord, there was no court proceeding, my lord. 18th, my lord, I have taken a permission and I have moved on 18th itself.
No,
14, 15, Saturday and Sunday, my lord, 17 was a holiday.
No, but whatever it may be, but after the disposal.
My lord, the contract has not been awarded to anybody now, my lord. The process, my lord, financial bid has been opened, my lord. It is my case also, financial bid has been opened.
Right.
Reverse auction process has been over on 18/6. The document itself will show. I have annexed the document. It is not that, my lord, that has been
So perhaps you missed the bus. Because
my lord, in my humble submission, my lord, I have not missed the level of 14th they intimate, my lord. 11th I have submitted my representation, 14th at 7 something, my lord. They intimate in the night, my lord, that communication, my lord, in the web portal they have communicated that your bid has been, my lord, your representation has not been considered because these are the additional documents which you ought to have been submitted at the time of submitting the bid. My lord, in fact, your lordship will kindly see that I have manual for procurement of goods. I have referred to clause 7.3.5 in one of the paragraphs. That has been also quoted in the minute, that has been considered by the single judge. In the same.
No, now see, interference by the court will derail the whole process of the process undertaken by the authorities. Only to satisfy whether your rejection was correct or incorrect.
Well,
technical bid is open, financial bid is open. They must have
technical
already.
bid was open. Thereafter, I came to know that I have been disqualified. On 10/6, that was communicated. 11/6, I submitted representation. 14th, they communicate that your representation cannot be considered. 15th, they have opened the financial bid. Reverse process started on 16th, reverse auction process. 18th, it was completed. My lord, immediately, my lord, immediately, 14, 15, and 17.
Yes.
My lord, there was no delay on my part to, my lord, approach the honorable court, my lord. And, my lord, nobody has been awarded with the contract.
Yes. Respondent.
And, my lord, your lordship will kindly see the financial bid. That, my lord, after the, my lord, reverse process was over, my lord, I have quoted in one of the paragraphs the financial bid which, my lord, they have given is 44 crores, 45 crores, and 46 crores. My lord, these are the three persons who were shortlisted in the technical bid. They have given 44, 45, 46. My bid, my lord, your lordship will kindly the first page, 22 crores 97 lakh. My lord, it is not a public interest, my lord. My lord, in my humble submission, it is also a public interest. My lord, they should have applied the wine on the documents furnished. It is not a new document has been furnished, my lord. What I have given the documents, my lord, was that, my lord, after the death of my father, during my father was alive, during the father of the two of the petitioners, when he was alive, my lord, partnership, proprietorship firm was concern was converted to a partnership. The same Assam, my lord, supply syndicate. Then, my lord, it could not be given effect to because he was very much ill and all that. It was on 1/11/2023. Thereafter, the father died on 17/1/2024. Then 14/2/2024, my lord, the partnership firm was reconstituted, inducting the mother in place of the, my lord, father. My lord, it is a continuing firm, my lord. Your lordship will kindly find in the New Horizons case also, my lord, it says that it can be taken into consideration. And, my lord, what is a partnership? My lord, a partnership is not nothing a legal entity, my lord. Not a legal entity, my lord. It is a continuation of the old form, my lord, of the proprietorship into a partnership. My lord,
Yes.
Lordship, page 133, by this order, Lordship, it has clearly stated on which ground his representation was rejected. He has not submitted the necessary documents, and so there was enough opportunity given to the Lordship bidders to submit all the documents. Lordship, may I read, Lordship?
Yes.
The bidder has participated in this GM bid with bid-specific authorization from MS Havels, so and so. The original offer of the bidder has been deliberated on the basis of the GM bid conditions and the offer submitted by them, and accordingly, disqualification has been communicated to them. The bidder has submitted annual turnover certificate which has not found to be relevant for the bidder, and accordingly, the disqualification has been communicated to the bidder. Now, the bidder, along with their representation, has submitted additional documents. It is to mention that the instant bid has been published on 22/3/2023 2024 and opened on 19/4/2024.
So essentially you have
Yes.
rejected because the documents did not pertain to the partnership firm.
Lordship.
It was of the
The
proprietorship firm.
And there is no connection between this partnership firm and the lordship proprietorship firm. Because proprietor is not a partner lordship, he has already died. But all are new partners lordship. Maybe his son or wife, but this is not a continuation of this partnership proprietorship firm. So it is admitted that it is his the assets of the proprietorship firm has been the assets of this partnership firm. But it has to be clarified.
So but the entity in its name had executed the work earlier. This entity,
Lordship.
whether it was proprietorship or partnership, had already executed some work. Is there any defect in this work? Which
Lordship
has the railways raised an objection that no, these papers are not
submitted.
not proper papers are not submitted,
Submitted.
or even if viewed from the perspective that they are one and the same entity, except for the nature, except for the nature of the entity. Instead of being a proprietorship, it has become a partnership firm.
Proprietorship firm is constituted on lordship 22nd March registered as per the certificate of registration of lordship on 22nd March 2024. And proprietor.
All right, we are issuing notice here, and it will be listed immediately on reopening, which is on 15. You don't issue the work order as yet, and you get all your records. We'd like to see your records. Right? Heard Mr. K.N. Kamal Agarwal, Senior Counsel, assisted by Mr.
D. Agarwal.
D. Agarwal, appearing for the appellants, MSR Devi for the respondent railways. The appeal is directed against the judgment and order dated 19/6/2024, passed by the learned single judge in WPC number 3134 of 2024. So the primary grievance urged in the appeal is that the petitioner's bids submitted in pursuance to the NIT number so and so issued by the railways was rejected at the technical bid on the ground that the documents which was submitted in support of its in support of the execution of the works undertaken by the entity / the bidder pertain to the period when the entity was a sole proprietorship concern. Stop. Subsequently, with effect from January 24.
Lord, 14th of February. My Lord, 14th
When did you become a partnership?
partnership became in 111, my Lord.
1/11/23.
1/11/2023.
With effect from 1/11/2023, the
And reconstituted on 14/2.
sole proprietorship firm was converted into a partnership firm and subsequently reconstituted in the year 2024. So, learned senior counsel appearing for the petitioner submits, for the appellant submits that the respondents did not take into account the aspect of this aspect of the matter that the works executed by the entity were not questioned or disputed. Only the nature of the entity was changed from a partnership, from a proprietorship firm to that of a partnership firm. So he has relied on the judgment of the apex court rendered in New Horizon versus Swento, where he says, on which he submits that the court, where required, where necessary, the court can lift the veil and look into the uh, the works, look into the experience of the works executed by any one of the entities in the case of joint venture. So in the present tender process, the only question to be decided was whether the entity in its capacity as a proprietorship firm had actually executed the work, notwithstanding that it had been reconstituted as a partnership firm. Stop. The documents which were submitted in terms of the provisions of the bid in the nature of clarifications were not considered in its proper perspective and rejected. Under such circumstances, uh, it is submitted that the impugned judgment by the learned single judge did not consider these aspects of the matter and had dismissed the writ petition, and being agreed, the writ appeal has been filed. MSRTB done at CDC for the railway submits that the petitioner was rejected, the technical bid, subsequently financial bid was also open, and
So, Lordship, the parties are not, Lordship, respondent, Lordship, who have already been selected, and they will be
submitted
affected,
that
Lordship.
pursuant to that, the authorities have proceeded to shortlist the L1 tender. However, the same has not been carried as a party, and therefore, at this stage, the appeal, there is no merit in the appeal, and the same should be rejected. Having heard learned counsel for the parties, that notice be issued, returnable on 15th of July. Stop notice also on the say interim prayer, returnable on the same date. The respondents will produce the records pertaining to the settlement, pertaining to the
bid in question.
bid in question, and before the court for perusal if the need so arises. Till the next returnable date, the respondents will not proceed to issue the work order to the shortlisted tenderer. This interim order is granted on the submissions made by the council for the appellant that there is a difference of what is the amount, what is the difference?
50% amount is, my lord, our bid is 22 crore.
So 20 crores.
22 crore, 22 crore, and their bid is 44 crore, 45
So-
crore, 46
So
crore.
20 crore,
Only,
difference of 20 crores,
50%.
which the bid submitted by the
And two of the bidder are the same, my lord, same from the same year. The BLB Mercantile and this BB International.
that will consider on the advocate on record for the appellant will furnish sufficient extra copies to the council for the respondents. Within the course of the day, you give a copies. Matter be listed and directed on 15th.
15.
Also, the maintainability of the petition, since the necessary parties have not been carried.
But on that day, financial bid was not finalized on that.
We'll see on that day, on the return if required.
Because I
If
can't
required,
give something new which was
we may not be convinced with the arguments made on 15th, we may reject it also. If we proceed, then obviously we'll have to direct.
Will be in touch person, Malak.
Why? You're
Hello.
questioning the transfer.
Hello.
You join on protest. You decide the matter later. Why should we? You're not losing your job.
Technical appeal number 1.
Yes, what is the urgency here?
Lordship, the urgency is that, Lordship, in this matter, prior permission has been accorded in favor of a school, which has no existence in the eyes of law, because there is a minutes of meeting which states that the name change is illegal. Now, prior permission has been accorded in favor of
When was it granted?
Lordship. It was granted on 15/3/24. Thereafter, it was
Then?
cancelled. No, Lordship. Thereafter, it was cancelled on 23rd of April, and thereafter again, and it was upheld on 31st of May.
Then
Now, Lordship, they are proceeding with granting of UDIs. Now, Lordship, if that takes place, the whole matter stands to.
who are you in the first place? Who are
Lordship,
you?
I am a guardian of the students studying in the school.
So how are you affected?
Lordship, I am affected for the fact that, Lordship, earlier, in the earlier round of litigation, there was a representation towards consideration. Now, if the name change itself is illegal, and thereafter action is taken against the school, Lordship, my word will be nowhere, because there is already a finding that the name change is illegal. Now, if the name change is illegal, a permission cannot be granted in favor of such a school.
Where is that finding?
Lordship. That your Lordship will find that page 34, Lordship. page 34. Down below, Lordship, paragraph number 2. May I read it, Lordship?
Yes.
As there is no legal standing for the change of name of the school to Moirangsam Dev Singh Memorial Academy, neither is there any problem for the original name to be retained. The headmaster Sri so and so is to reconsider the change of the name. Now, Lordship, this minutes of meeting was challenged by the headmaster before this honorable court in writ petition number 8028 of 2018. Thereafter, in 2022, he had withdrawn the writ petition, meaning thereby, Lordship, this minutes of meeting has attained finality, and there is no grievance as regards the finding that the name change is illegal. Even after that, Lordship, prior permission has been
Is
accorded.
there a judicial order to that effect?
To the effect.
That name change is illegal?
Lordship, they had challenged this minutes,
Huh.
and thereafter they had withdrawn without any liberty.
Then-
That order is there. Lordship, they
Yes.
had withdrawn without any liberty. Therefore, Lordship, this
Now,
minutes of meeting.
what is the standing of the DC here?
No, Lordship.
What role has the DC got?
Lordship, a meeting was convened for the fact that Lordship mutation certificates were issued in their favor. And Lordship, thereafter a meeting was.
So you are now challenging the change of name.
Lordship, I am challenging the speaking order, impugned order at page 48.
Page number
48, Lordship.
48. Yes.
Now, Lordship, prior to this, Lordship, in the petitioner had approached before this court in writ petition number 1110.
This was ordered on
Lordship,
31/5.
5/2024.
Then?
No, Lordship, this was communicated to me. They had filed a caveat, the other side. Caveat copy.
Somebody is on caveat.
Yes, please,
Oh.
Lordship,
Heard Mr. D. Chakraborty, Learned Counsel for the caveator. Caveat is that. Yes.
Lordship, now, thereafter, Lordship, caveat was filed. We had received a copy of the caveat on 8th of June. Till then, Lordship, this impugned speaking order was not communicated to us.
All right. We'll
It
hear
was communicated on.
heard Learned Counsel for the party. Counsel for the petitioner, Mr.
A. Chakraborty.
A. Chakraborty. And Mr. Chisti for
For
education.
Restaurant 1, Rossi 1, 2, and 4.
1, 2, and 4.
And my friend PK Bora for restaurant number 2,
Mr.
3.
Bora for
3,
3, director.
Director Elementary.
And who's for 5? Mission director.
5 days of separate standing council SSL Rossi. As Bora is there.
You accept notice now.
Whether he's
Mr.
copy instruct. Copy of
Mr. Chisti appears for respondent 5 also. What about Mr. Chakraborty?
I'm appearing for 7 and 8, my lord. I filed wakalat.
The caveator enters appearances on behalf of 7 and 8. Let notice issued, returnable, repeat. Since the standing councils have already entered, since the councils represent the respondents, except respondent number 6, notices are waived, extra copies be furnished within a period of 1 week. 2 weeks. Steps on respondent 6 by registered post and usual post within 1 week. Notice on the prayer of interim may be made returnable on 5th of August. Had to be listed on 5th of August. Respondents to complete their instructions and may file their counter affidavit if so advised.
Question of maintainability can be kept. He has no
Yes.
locus standi in filing with.
The respondents urged a question of maintainability, which will be taken up in consideration on the next.
Extra copies. Extra copies.
Extra copies.
Extra copies we furnished, we have already ordered.
Obliged.
Yes.
Here, my lord, the road is under reconstruction, my lord. There is Vivekananda Road, my lord. And the petitioners were never served with any notice and all if the portion of land of the petitioners are taken. That is the case, my lord, because now they
You
are,
are occupying what land?
no, I am the patta land, my lord. I am the patta holder.
Patta holder.
Yes, madam. Both the petitions are patta holder, madam. At any moment, it may be dismantled, madam, without acquisition or requisition of the land.
Yes, what do you say, respondent?
Well, in absence of instruction, it is difficult on
How
my
can you
part.
get how soon can you get instruction?
Lordship, at least I need the
2-3 days time I need. Otherwise, I have seen the petition, they are on apprehension. They are on apprehension. There
You
is
get
no,
instructions, we are fixing it on the next available vacation. When get here? 11th, 11th of April, 11th of July,
11th.
or you wanted after reopening?
On the day of reopening, kindly take it on 15th or 16th. Maybe take it on.
The petitioners are before this court.
No.
It's enough. Petitioners are before this court apprehending that the respondent PWD department will
Huh?
demolish their, will take over their land, which is by the side of, which is adjacent to what road is this? Vivekananda Road in the district of Silchar, for purposes of widening and construction of the road. Of the petitioner's homestead is situated on a land measuring 2 kata, 8 chotak, covered by tag number 134, patta number 42, Bhudatara, part 3, Vivekananda Road, Silchar. I stop. The petitioners apprehend that no notice has been served for acquisition, and the respondents are in the process of widening the road, and there is a serious apprehension that in the said process, the respondents will unauthorizedly occupy, take over a portion of the land and cause damage to the dwelling houses of the red petitioner. So being agreed, present red petition is filed. Mr. Dinath, senior government advocate, submits that you'd like to obtain instructions in the matter.
I am appearing for respondent 1, 2, 3, and 4.
Appears for respondent 1, 2, 3, and 4.
1,
You
2,
want
3, and 4.
notice?
Yes, sir.
Accordingly, the notice we issued return to 2 weeks. Mr. Nath appears, accepts notice on behalf of 1, 2, 3, 4.
1, 2, 3, 4. My
And
11th
5 and 6 I'm enjoyment. You that's
MSU does appearing for respondent 5, 6, 5 and 6.
fine.
Who is this 7?
is contract firm.
Steps on respondent number 7 by April 4th, registered post AD. Matter be listed again on 19th July.
No taking over without due
Meanwhile,
process of
the respondent authority will not take over any portion of the land claimed to be under the possession of the writ petitioner without following due process of law.
yes, sir. Another here the land measuring, one is 2 kata, another is 6 kata, 12 sotak.
In fact, their allegation is that boundary wall will be affected. Otherwise, they are agreeable
No,
that
no.
if acquisition is done, they have no objection.
No, in 2 kata land, my
That-
house
that-
will be taken away. Only 2 kata land.
The 2 kata land is not
They are
required.
agreed
Only
that
for
you
widening of the
will
road.
take over the land without compensation.
That is their.
That is also one
Logic
thing.
has said without due process. Logic has said.
Yes.
There
Always.
are 2 portions of the land.
Obligable. Hello.
Yes.
May it please your lordship. Well, that's page 12 is the tender notice. Yesterday,
Blacklisted.
no, I was blacklisted once. There is no
But this is a perpetual blacklisting.
perpetual plan.
How will
No,
anybody
but
take part?
Yeah, there is a provision in page 28 lawsuit mechanism within the bid document
28.
28
Yeah.
below lawsuit.
Yeah.
Further, if any seller has any objection, grievance against these additional clauses or otherwise, or on any aspect of this bid, they can raise their representation against the same by using the representation window provided in the bid details in the field in seller dashboard after logging in as the seller within 48 days of the bid publication on Jan. So they have the provision. Look, if they have any objection, they could have online submitted the representation before.
We have done so.
No, lordship. That is the reason. They have done it physical. And that too without these annexers have no receipt. Lordship, kindly peruse annexer C
So
and
there are soft
B and
copies,
C.
we can give it through email and hard copies too.
There's a specific provision there.
You have submitted through email.
Email and hard copies both.
No,
I specifically put this question to my client. I stand on that this morning.
Have you stated in your writ
No,
petition?
Nothing.
In the writ petition, what we have stated is that we have represented. This morning, I put a specific question to my client. How did you send it? He sent emails and through hard
That
copies.
should have been there as a part of the.
But
brief.
that's
that would have clarified. Also.
absolutely, Milord. Yesterday was the last week closing time and date.
All right.
We
And
participated.
yes,
And the last line,
Examine this and see whether the
Yes, Lordship, we
representation.
have not taken any decision. It's a great premature, Lordship.
absolutely.
We have not taken any decision.
No,
Yes, the
Don't keep on a life ban.
No, correct. But if you blacklist somebody and normally blacklisting is for a particular period of time, ordinarily, 2 years, 3 years, 4 years, whatever.
clause is there, but we have not taken any decision, Lordship. His bid is open yesterday, and he has participated. And there's a provision for filing online.
We have-
petition, Lordship.
No,
That
no.
They have not filed.
No.
In a
Your
particular
bill is your clause 8, 23.8
28.
is very categorical
Yes, Lordship.
that if you have been blacklisted or debarred, you will not be allowed.
Yes.
So admittedly, he has not suppressed the fact.
Yes.
He has been blacklisted.
Yes.
But for 2 years, is it?
No, it was for 3 years. June 12th,
That
15th.
clarity is not there in the petition. There's pleadings.
Yes, please, is there. It's there.
Only statement is there.
That's pleadings.
When you are delisted,
That's
when that
pleading.
was over,
It's there.
there is nothing.
No,
there.
these
I would read out that paragraph, Milord.
But right now, at this moment, you find out whether through email, any representation has been filed.
That will not be acceptable. No? It is specific provision is there in that particular portal.
Hmm.
So he have to file any representation to the portal.
Have you filed in the portal?
Yes, I put that question to my client, and that was the answer.
recording
They
it.
sent through the email and all.
But my specific instruction he has not filed.
You
Page 30 and
Yes.
31.
Lost.
Page 30 and 31
That
when sent through
specific
emails.
instruction I have received.
received.
But tall and short of it is that whether they can put a life ban on that, technicalities aside.
And if it doesn't follow the procedure, lordship, the Central Coalfield Limited that judgment is there. He have to follow the requirement, lordship.
CCL goes both ways, Milord.
Point 11, lordship, mechanically in the next page. Eleven,
So
12.
they have
thereby-
gone into the integrity and this and that. Hey, clause 10, you see. They've made up their mind that they don't want blacklisted bidders. So you'll have to justify that. You may say that blacklisting is a condition which goes against them. But can you debar them completely?
Till that lordship, we are not debarring him.
No,
He has a-
it's there in your, you read clause 10.
Yes.
You read clause 10, you read clause 7, very clear intention.
And that is regarding that clause. But whether he have any grievance, that he should have filed his repentance through online lordship. He has not filed anything.
All right.
Until unless
If it
we
is
have to
not-
come to
if
know
it is
that
not
what
filed
was his
through-
grievance. We definitely will sort it out.
So you
And yesterday only bid was technical bid is still far away, lordship.
No,
Yes,
technical
1730.
se-
1730.
technical bid was open.
Open.
No, bid document was open yesterday, lordship. Now technical evaluation will be done later on, lordship.
I'm
So
only
his bid was not obviously not open. In view of this clause 20.
Like yesterday bid was open and it was found that he has not submitted. It is there, lordship. May kindly see
Hmm.
the clause 13. Further, at the end date of bid was being 017/2024 at 5 p.m. The
Very
bid was
well,
open
you
at 6
consider
p.m.
that.
And we observed that the petitioner to participate in the bid as a seller.
Mr. S. Bonik, learned counsel to the petitioner, Mr. S. T. Chisti, appearing for the respondent.
All are responding.
All respondent. Petitioner is before this court agreed at by clause 23.8 in the bid document. You have submitted your bid.
Yes.
So you have submitted your bid and you have challenged the bid.
We have stated so. We even represented saying that kindly consider this clause. They do not. I do not have time. So under protest, we submit, Milord.
Because-
In respect of the bid, dated 2006-2024 issued at the GEM portal, GEM portal by the Adarsh Vidyaloy Sangathan for supply of various items. So, petitioner submits that at clause 23.8 there is a stipulation that bidders should not be blacklisted or debarred at any point in time by any central/state government organization, PSU, government educational institute, etc. And an undertaking to be submitted from the bidder. Stop. It is submitted by the learned counsel to the petitioner that the bidder was blacklisted. By what? By
IIT Guwahati.
where?
IIT Guwahati, may know that page 5, paragraph 4.
Was blacklisted by the IIT Guwahati at an earlier point in time during the execution. Which date was it?
Sometime in June 12th, may know.
In the
I
year
recall that.
2012. Stop. Subsequently, the bidder thereafter subsequently participated in several contracts of the IIT and has also been awarded contracts. Stop. However, the clause 23.8 in the bid document categorically debars any bidder who had been blacklisted in the past to be a participant in this bid. Stop. In view of the apprehension expressed, the petitioner is represented before the authorities by in the portal itself.
No, Lord.
That was given to me.
That is
This is
not.
the email given to me.
Huh?
A copy of the email given to me by the client.
It's an email.
Email.
It's an email sent to me. However, they put it up, I do not know.
No. Is it an objection raised in the portal itself or?
I have not put whether it's portal or not. Whether given hard copy or soft copy, how did you
So,
there is a specific
the
provision of
petitioner
making-
submits that by way of an email as well as by hard copy, he is
Lordship.
represented before the competent authorities, but no action has been taken. This ground. Stop. Meanwhile, it is submitted that the technical bid has been opened, but the respondent authority has not declared the result as on date. Mr. T. Chisti, learned counsel for the respondent, strongly disputes the submissions made by the learned counsel for the petitioner. He has placed a copy of the instructions received to submit that as per
Page 28 looks like the provision may kindly be.
as per clause 24 after clause 24 in the bid document, there is a provision for raising objections or grievances
Under disclaimer.
or in any other aspect of the bid by providing the various bid details in the seller dashboard after logging in as a seller within 4 days of the bid publication of the on the GEM, GEM, G capital G small e capital M. So you say as per the condition under the disclaimer. Okay. It is submitted that in spite of provisions being granted, no such steps have been taken
And we have not received any representation.
and no representation has yet been received
On-
as
in a portal.
claimed by the writ petitioner. So, he, however, submits that the technical bids have been opened, but the respondent authorities have not shortlisted the valid tenderers. That are having heard an account of the parties, let notice issue returnable on, tell us when you want it. 17th?
Yes.
17th July.
July.
Since Mr. Chisti appears on the respondent, notices the waive extra copies are furnished within the course of the day. Extra copies?
Right away.
Yeah.
Or he can have it now.
Okay.
Since a question has been raised regarding the correctness of the of a clause of the tender, barring bidder or a prospective bidder from participating if they are blacklisted. And this bar and the effect of the clause that the intending tenderer would be barred throughout is opposed to public policy. Number one. Let the authorities respond to the contentions raised by the petitioner as to whether the emails / the representation stated to have been furnished have been received, and if so, whether any decision has been taken by the respondents on that. Meanwhile, till 17th, let the authorities proceed in the matter, but they shall not. Have you decided on this?
No, no decision. My specific instruction, there's no decision. Only bid was open yesterday, Lordship.
All right.
Nothing else.
Let them proceed on the decision of the technical bid, but the result shall not be declared without leave of the board.
Yeah.
Obliged, Lordship. Grateful.
The further continuance of the interim order will be considered again on 17th.
Grateful. my lord.
For withdrawal, I have four.
It is submitted by the learned counsel to the petitioner that the petitioner does not wish to press the petition and seeks liberty to withdraw. Same. Accordingly, the AP petition stands dismissed on withdrawal. Interim orders, if any, stand vacated.
Five.
Same order, bail application stands dismissed on withdrawal. Orders, if any, stand vacated.
Obliged.
For total, here I have six.
Third learned counsel. Petitioner, call for CD.
My lord.
When can you get it? Hatigaon.
Well, a similar matter fixed on 16/7. So maybe
Matter be listed on 16/7,
my lord, on 16, my lord, I will be out of station. So 18/7.
18/7.
My lord.
Call for CD. Mr. Sharma, okay?
My lord.
Mr. P. Sharma, original APP appeared. Okay. List on 18th.
18/7.
18/7.
Okay.
Six, seven.
Third, the party issue no. Call for CD.
But offensive report, my lord.
Oh, this is wildlife.
Wildlife matter, my lord.
Call for offense report. The council appears for the wildlife. or
My lord.
Wildlife.
My lord, special PP wildlife.
Special PP wildlife. It's on, tell us.
My
When can you get it?
My lord, on 18, my lord.
18 July.
My lord.
List on 18 July.
Item eight.
Lordship, for the timing, Lordship.
Timing?
The
No
Lord-
timing today.
Lordship,
We
Mr.
are
Moody,
only calling for the
My lord, CD, my lord.
CD.
My lord.
I'm not in the case, Lordship, and Mr. Munir is in the court number 20, Lordship. For the timing, Lord. I'm calling.
Till the court rises.
Item nine.
My lord, here also, Lordship may call for CD only.
Yes.
21B, 29, my lord. Up to days 35 days, my lord. CD on my lord. 16th, my lord.
Yes.
Third, council for the parties, call for CD. List on
16th, second.
16
Mile.
of July.
My lord.
Obliged.
Ten.
Then this minute 439, my lord. The FIR is 13. FIR filed by the police, my lord.
When were you arrested?
Arrested, my lord, on
14/6,
14/6,
my
my lord, to 19
Third,
days, my lord.
Mr. Ali, Mr. P. Sharma,
Mile.
call for CD. This is from Ratabari.
Lost.
Kolimganj, my lord. 18th, my lord.
18th,
18th.
18th of July. It's on 18th.
Seven.
Third, Mr. Diami, Mr. P. Sharma, he call for CD. On 18th,
My lord, 19th, my lord.
follow move.
99 for
Huh?
18, my
18th,
18th.
hold on 18/7.
12,
My lord, 21
Golf
PM.
City.
19th, my lord.
It's on 19th July.
19th, my lord.
13,
Yeah, Lordship. On Lordship, 11 of Lordship.
When were
July.
you arrested?
Yes, Lordship. On
When were you arrested?
26, 2024, Lordship. And 13 days, Lordship.
Third level. It's Golf City.
My lord, 22nd, my lord.
Saptagram.
No, 11th of Lordship, I mean submission 11th of next.
No, my
I am
lord.
totally innocent,
Vacation-
Lordship, and the
Vacation
servicemen and Gaura also they are Lordship. in this case, Lordship.
326 is here, my lord.
Yes, Lordship. I love denied Lordship.
395, 326 is here.
Yes, Lordship, and Gaura and totally innocent Lordship in the Lordship case.
When do you want it?
There.
11th.
11th of July, Lordship.
11th.
11.
Vacation court, my lord.
Yes, Lord, vacation court,
11th
Lordship.
vacation court.
I know.
Yes,
You
Lord.
call for it and see.
Yes, Lordship. With medical report, Lordship.
Federal Council, the parties submits that matter be directed to be listed on 11th
My lord.
of July, the next vacation. So accordingly, Golf City along with medical
Medical report.
list on 11th.
Yes, Lord. Obliged.
or more than item 14,
It's a transfer petition, my lord. I'm the wife. Husband has filed a divorce suit in Biswanath Saheli, my lord.
You are staying in Nogao.
I'm staying in Nogao, a minor
Not very
child, my
far.
lord. My lord, he is not maintaining me, and I have filed a domestic violence case in Nogao. He is not appearing there.
All
It's
right,
a criminal case.
Federal Council for the parties issue notice. Returnable on 19 July. Steps on respondent by registered post AD along with usual course. Custody is also permitted. Based on 19?
My lord, case is fixed on 5th before the Biswanath court, my lord. Till the returnable date, my lord, proceedings will be paid. Already, my lord, there are coercive measures initiated against him in Nogao. He is not appearing in
You
Nogao.
intimate the court
My
that you have filed for a transfer petition. You file an application there.
lord.
We are not staying the proceeding.
Very difficult for me with a minor child, my lord. I'm the wife, my lord. Not maintaining me, my lord.
No,
Till the next date, my lord. if
no,
he does
no,
not
we
appear,
can't
my lord.
stay it. Why should we stay it?
But it's very, my lord, with a minor child, he is not maintaining
We
me, my
can't
lord.
stay it like that.
1 year.
This is a proceeding.
1
We have to, there must be an attempt to expedite the proceeding. Why are you calling for a stay? You want a transfer, we'll examine it, whether transfer is.
Since it's fixed on 5th, my lord, I'll have to go and otherwise it will proceed ex
You
parte, my
must
lord.
file an application saying that the matter has been filed before the court seeking transfer. No stay. A prayer for stay will be considered on the returnable date.
Deep level.
Yes, yes, yes,
15 and 16 may be taken together.
yes, okay.
Now, so far the 15 is
You
concerned.
want the car back.
Yes, this is a case under section 13 and 14 of the Assam Games and Betting Act.
Hmm.
Now, the car of the petitioner was seized. It is not an instrument of betting, my lord.
He must have carried that instrument of
No,
betting
no,
in the
no.
car.
No, nothing. There was no allegation. There was no allegation. The instrument of betting, that's not covered with this vehicle. Unnecessarily, the vehicle was seized. And Lordship is aware that he is cannot be put under the control of the police beyond the 15 days, as per the Sundarbai Ambala case. And moreover, 9 weeks has been passed. He was seized on 26th of April. The only my vehicle, that's the only issue. Lord.
Later, wait,
Yes, so we have to take instruction whether it is required for further
But
investigation.
that one's already been,
already held.
he has already been held. IO has objected. IO's objection is that the way from this car was purchased,
We'll
source of
give
money.
him one opportunity, we'll fix it on 11th. You get your instructions on 11th.
The Lordship may kindly appreciate that
We
the
are
report has been called for by from the investigation
all
officer.
right, but we have to give him one opportunity. Should we not give a counsel an opportunity? We'll have to give him an opportunity. The earliest we can give you is on 11th.
Lordship.
If 11th is not convenient, we can have it after reopening.
On 22nd.
22nd
of July.
Right. Heard Mr. P. Dattol, counsel, senior counsel, assisted by Mr. Deka. S. Deka. Mr. B.V. Gogoi, additional APP, appears for the respondents. Let the respondents obtain instructions.
22nd, na?
Learned APP will obtain instructions as to
The reason for seizure of this
reason
vehicle.
for seizure of the vehicle and for keeping it with the on opposing the Zimma prayer of the petition of the petitioner. Stop. What about the second?
That's a statutory violation. Passport was seized. That cannot be under Passport Act. And cash amount of 10 lakhs. I will give a bond for 10 lakhs rupees.
So let these matters be listed again on 11th.
No, 22.
22. You want it on 22.
22. The item number 15.
15 and 16, let it come on 22.
Lordship, this 16 is there seized 10 lakhs.
Whatever it may be, we have to give one opportunity.
Same police station, same person matter.
If the state did not complain, we could have disposed of matters on the same day, but we are required to give them.
It's a matter to be disposed, Your Lordship, on the motion itself.
Ordinarily, yes, but this is a vacation bench. We'll have to give them some instructions. Otherwise, we could have kept it for day after or something like that. But the earliest we can give you is on 11. But you don't want it on 11.
11th again I have to come.
You don't want to come on vacation. List these matters on 22nd of July. As prayed for by the learned councils, the additional APP will obtain instructions and the prayer of the petitioners will be considered for disposal.
Yes. Both the matters.
Both the matters on 22nd.
On 22nd.
May I please, Your Lordship?
Yes.
This criminal petition is filed challenging the charge sheet, my lord. Charge sheet number 53/2024 dated 30/3/2024 is Annexure F in page number 40 to 49, my lord. It's submitted by the officer in
You
charge.
call for the scan copies.
Scan copy notice will
Notice.
yes.
Heard
Because 498 it is.
petitioner issue notice on the respondent number 1 by registered post and usual course. Mr. B.V. Gogoi appears for additional APP, appears for the public prosecutor. Registry to call for the scan copy of the case records pertaining to. It is still in this. It has been filed before the court, right? Vishwanath Charil, is it? What is the case detail?
My lord.
Baihata Police Station.
Baihata.
Under section so and so, pending before which court?
In SDGM, my lord. Charge sheet is submitted in the court of SDGM Romia, my lord.
SDGM Romia. So, let the matter be listed on 26th of July.
Yes, my lord. 26 July, my lord. Pending disposal interim, my lord. Charge sheet may be suspended, my lord.
Why charge sheet could be suspended?
My lord said me.
We will have to hear you on the interim. We are only issuing notice. If you want a shorter date, we'll give you a shorter. 19th July.
19th July.
Prayer for interim to be considered on the next date.
19th July.
The prisoner before Lordship, my lord, is a local businessman of Vishwanath, my lord, and he has been succeeded in a case, my lord.
He's
Well,
not
I'm
appearing.
checking. And warrant of arrest has been issued against him.
He's not appearing.
I understand, but because he has some physical inabilities, my lord.
What?
What, but my lord, he was suffering from some gastral problems, and he was bedridden for many occasions. He has taken treatment from Apollo Chennai, my lord.
Where is that order?
Last order, you'll also find at page, page 16, my lord.
Yes, Mr. Bhuvi.
Yes, my lord, this case of my lord 2014,
No, they restarted 2021 in session case.
FIR 14.
FIR 14 was committed in year 21.
NBWA, my lord, let him appear. Some protection may be given, my lord.
This petition is agreed by the people order dated 12/6/2024, asked by the Court of Additional Session Judge in Sessions Quiz number so and so. And the Sessions Court has issued an NBWA against the petitioner fixing 26/7/2024 as the next date. The counsel said for the petitioner submits the petitioner has been suffering from serious medical ailments and has been undergoing prolonged treatment. He is referred to the various medical documents exposed to be petition in support of his contention. Learned APP appearing for the state submits that this matter is a very old matter pertaining to the year 2014.
FIR 2014.
The FIR was lodged in 2014. And therefore, petitioner be directed to appear on the next date positively without date. Having heard and counsel for the parties, considering the facts involved in the matter, let the petitioner appear before the court on the next date fixed, which is on 26/7.
26/7.
So, in the event the petitioner appears before the court, the competent court will recall the NBWA and consider such a prayer for bail as being filed by the petitioner. Stop. Till the next date fixed, the NBWA issued by the order dated 12/6/2024 shall not be enforced against the petitioner against the petitioner. Stop. In the event of the failure, the petitioner to appear is directed on 26/7/2024. This interim protection shall stand vacated without further reference to the court, and the competent court will be at liberty to pass appropriate orders as deemed fit and proper under the provision.
The next case also, the same order will prevail, my lord. Only case number will be different.
Same person.
Same person. Two different cases.
Two different cases.
Here also he was ill.
Uncheck.
Was he medically?
Yes, my lord, the same person, my lord.
Same person.
All yes. And the order is you'll also find at page 21, my lord.
Page 21.
That is the next date is fixed on 26/7.
21. Same order. Next date fixed is 6/7.
6/7. Yes.
If he appears.
And session case number 136.
And the sessions case number 136
of
2016. If he appears, then NBWA will be recalled and orders for bail will be issued on such application filed with the petitioner. And till the next date fixed, NBWA shall not be enforced. However, in the event he fails to appear as directed, interim order passed today, then it stand vacated without further reference to this court. Suppose. Yes.
These are 482 application. The FIR is at page 16.
You're praying for quashing.
Yes.
Of the FIR.
Yes. So, petitioner 1 is already in custody for 40 days. We are applicant of 2 to 7, who are the mother
brothers and sister-in-law of the accused person, FIR is at page 16. May I read?
What is there to read? We are issuing notice here.
Yes, my lord. POCSO section is there.
What has happened, it has been,
Issue
Let
notice,
them come.
returnable after 3 weeks. The steps on respondent number 2 by usual course registered post. Be returnable on the same day. Mr. P.V. Gogoi, learned APP, appeared for the
Trial.
state.
Oh. CD like what?
Call for CD. Perusal of the court. As the present petition is filed, praying for quashing of the FIR dated 19/5/2024, lodged by the informant. Based on 29th,
Lordship, there is a bar of 438, therefore, till then, no course of measures.
No,
he's already arrested, you said.
No, we are appearing for 2 to 7. One is arrested, that is the prime accused. There is no allegation as such in the FIR. Lord. That is why I wanted to read that.
We'll have to, then we'll fix it on 15th. Can we have it on 15th?
Yes.
15th of July. The interim prayer to be considered on the next date fixed.
Diplomat.
These matters were directed to be listed after summer vacation.
But
last order, already an order on 27/6.
in the last occasion, it was listed, but due to shortness of time, it could
No,
not.
no, there's an order here.
Judicial order is there.
There's an order. That apart, regarding the same FIR, there are other matters which are pending before coordinate benches.
No. Regarding this matter, your lordship, only these two petitions.
These matters arise out of an FIR, and in respect of that FIR, there are other matters pending.
So in respect of this FIR, your lordship, only these two petitions.
No, this is not what the office says. You have a look here.
Or does it say, sir?
You have a look.
Lordship, see the FIR, your lordship.
No, you see.
Forget.
You see the office note here.
Today it is.
First see that. There is a notification.
Yes, maybe, your lordship, but here in your lordship, the petition in respect of item 21, your lordship, for 65 days, your lordship, he is in custody. Perhaps your lordship is.
Out of the same FIR, there are three cases.
It is fair.
But on that day, your lordship, on 27/6/2024, your lordship, this matter was, on that day it was listed, but due to shortage of time.
We go by the orders, what can be done? There's an order. We'll have it on 15th. Third learned counsel for the parties, since there is already an order directing the matter to be listed after summer vacation. The matter be listed before the appropriate bench on 15th of July. 2027 at 2024. 15 July. On the reopening date.
15 July, your lordship. 18 July, your lordship.
Listed immediately after summer vacation and as requested by the counsel for the petition.
I think
on
your
18th of July.
Herein, this matter has been listed today only because of that in last occasion CD was there.
No,
And
it is listed because somebody mentioned it. It is listed because otherwise it doesn't come in a vacation bench. It is listed because
it was
the counsel for
it was
respondent mentioned.
It was mentioned merely because of that in last occasion CD was there, and this person is for 65 days.
But in view of this order, that order is already there.
But that order, your lordship, on that day actually no order was passed.
You go and
because
play.
The matter was
We go by the orders of the court.
But on that day, no order was passed in open court. Obliged.
He said only we are pressing now the IA for bail. What happened? He was convicted. And then the appellate court also confirmed the conviction. Before preferring the revision application, a warrant was issued and he was, last 33 days, he was in jail.
Yes, who's appearing here?
Oh, only 1 year conviction, 498 A. And on the merit also, Lordship may kindly take a note. There is 2 FIR. First
Both
FIR.
petitioners are behind the bars.
Yeah. Sister-in-law and the husband. And that also 33 days.
Dowry.
498A only. Not dowry. And there and before that, one first FIR was lost, that was registered under 498. Second FIR lost on the same set of facts, that was also registered. And I was convicted on the second FIR. And first FIR trial is continuing.
All right, heard. Learned counsel. Sitting counsel. Listed by Mr. D.B. Gogoi, learned APP for the state. Issue notice on the IA. Why issue notice? Do you want a notice?
It is maybe disposed of Lordship only 389. 389 may be disposed.
Criminal.
Now it has changed now. Now it is.
Has been filed on criminal revision 231 of 2024 has been filed, putting to challenge the order judgment dated 6th of May 2024 in criminal appeal number 55 of 2018, upholding
Both you have challenged trial court order and appellate court.
Holding the conviction of the petitioner. Oh, the trial court had dismissed.
The trial court has convicted under section 498 for a imprisonment for 1 year.
And then appellate court?
Appellate court affirmed.
Appeal.
Yeah. Affirm the judge.
Affirm the judgment of the trial court against the conviction of the petitioners for a period of 1 year. So, immediately thereafter, the petitioners were taken into custody and have been in custody since their date of arrest. When were they arrested?
31/5. 31st of May.
So, learned city council has filed his IA praying for suspension of the sentence during the pendency of the criminal petition, criminal revision petition. What do you say, learned APP?
He was there all on previous bail earlier. Earlier on previous bail, Lordship may also.
He submitted that during the entire course of the trial, petitioners were on earlier previous bail and had not defaulted in appearances before the court. Considering the submissions made, his highest has allowed the sentence of 1 year by the additional sessions court criminal appeal number so and so shall remain suspended till the disposal of the criminal petition 231 of 2024. The petitioners are therefore directed to be released forthwith by due compliance of the procedure prescribed in law. IA accordingly said.
Petitioner will be released on previous bail. Then
Only-
lower court are always confused. Otherwise,
Released on the previous bail.
yes.
I stands disposed, criminal petition be listed. Give us a date if you want.
Any day, you know, because the record is to be called for.
Record already called for.
Already called for. Record is already.
The date
After,
fixed.
after receive of the record, the matter may be listed by the registrar.
Since the record of the concerned case being GR case number so and so into water side note has been called for, the matter be listed immediately upon receipt of the records.
Grateful, Lordship.
Yes, vote.
I'm sorry, Lordship.
Yes.
Lordship, kindly turn to
We'll call for CD. What else?
Lordship,
Else?
accident case, Lordship, already
So-
behind the parlor. Lordship, kindly turn to case
Accident
8.
case, so what?
Lordship,
Person died.
it should come 304A, Lordship. Then it's bailable, Lordship. And police have registered as 304, Lordship. So therefore, he is behind the parlor. He is non-bailable there. And 304 does not attract, Lordship, to the
We'll have
offense.
to call for CD.
304, Lordship, does not attract, Lordship. Lordship will kindly see the contents of the FIR, Lordship, page 8,
Page 8.
Lordship.
Yes.
That we do respect the humble submission is that on last 15/6 so and so at 7, my mother along with my father Hemanto Das for their business work were crossing the National Highway 27 from Somnath Temple, Tetilia side to Ganesh Mandir. At that point of time, the driver of one bus being number so and so coming from Jalukbari side to Boragaon in a high speed and rush manner knocked my father, for which my father got seriously injured and immediately he was taken to Guwahati Medical College Hospital with the help of police, but on duty doctor they declare my death as well. So it's not intentional lordship, it's an accident lordship and it's a highway lordship. It's not any lordship lane or that he was driving in a high speed.
So
So it's a bailable section lordship. It comes under for A lordship, already arrested lordship. It's not pre-arrest bail lordship. Lordship will kindly see the section lordship 304A lordship. 304 does not attract lordship, so it's a count.
According to new Act 5 years. According to new Act 5 years. এইটো আগত হৈছে মই কথাটো কৈছো নাই
Lordship will kindly see the 304 lordship, this section which has been registered lordship 304 lordship.
Yes.
304 lordship, punishment for culpable homicide not amounting to murder lordship. Whoever commit culpable homicide not amounting to murder shall be punished with imprisonment for life and or imprisonment for either description for a term which may extend to 10 years and shall be liable to fine if the act is done act by which the death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death lordship. There was no intention, it was an accident lordship, and therefore or with imprisonment for either description for a term which may extend to 10 years or fine or both is done with the knowledge that it is likely to cause death but without any intention to cause death or to cause such bodily injury. Initially, lordship, what happened earlier, lordship, the 304 always added in the accident cases. Let us come to 304A, lordship. 304A, lordship, causing death by negligence. Whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punishable with imprisonment for either description for a term which may extend to 2 years or fine with both. Lordship is a bailable section. It should be 304A, lordship. And other sections are bailable, lordship. Only because of the 304 wrongly, lordship, section has been registered. That is why he is behind the bar, lordship. Initially, always 304 was added, lordship, in accident cases, lordship. It is a highway, lordship. And a bus was full of passengers, lord. He suddenly came, lordship, the accident, lordship.
What do you say?
Let the CD come, my lord. Without my lord CD, we cannot say anything.
Sure.
No, if
Whether this is 304 or
No,
40.
lordship will kindly say contents of the FIR, lordship. Why CD is required, lordship?
You may be more aware than the court.
No.
There are cases across the country relating to rash and negligent driving.
If
these are all under 304A.
Lordship.
Then why all the ruckus? Why all the controversy raised?
Lordship,
304A, 2 years, bailable offense.
So is a bus, lordship, and not.
One person died for his negligence.
No, how it can be? It is a highway, lordship. The bus was driving.
Highway is not
Highway doesn't mean that you.
I'm not saying that.
drive
The bus was full
without
of
any-
passenger, lordship. It is not an intention was there to kill that
Let us see
person.
the CD. Let us see the CD. We'll give you a short date. Third Plenary Council to parties. Call for CD. This is coming from
Jalukbari.
Jalukbari.
16.
16.
No problem. Yes.
All right. 16. 16 July. Call for CD. Along with what? Postmortem.
Postmortem.
Along with postmortem report. Just on 16.